Hello everyone, my name is Taiwo Olalere. I'm a Canadian immigration lawyer in Ottawa. I'm also a law partner at Olalere Law Office, a Canadian immigration law firm. We've been helping people to come to Canada for over 15 years, and we've dealt with various visa applications, study visas, visitors visas, work permits, permanent residence applications, federal court litigation, appeals. We do all aspects of immigration. So if you need our services, please don't hesitate to contact us on our phone number or WhatsApp +1 613 799 7572. Today I'll be talking about federal court application for leave and judicial review. This is very important, very important. If you're refused, whether for a visitor's visa or a study permit or a work permit or permanent residence, any kind of permanent residence, you can come to us for federal court application for leave and judicial review. So what is federal court application for leave and judicial review? Basically, you're going to the federal court to challenge a refusal decision. So the visa officer has refused your application, any kind of application. He has refused it or she has refused your visa application. Most times they don't put their names on the refusal letter. They'll just put, since they will tell you we've refused it on these grounds, and they will say sincerely, then they put the visa office address at the bottom. So you don't even know the visa officer that refused your application. So our job is to help you to litigate this, to take it to the federal court and challenge the decision. We will look at the reason for the refusal, and if you're ready to go to federal court after the consultation, we will help you to challenge it after you retain our services. So you have to first do a consultation with us. We look at the refusal letter, we explain the reasons they refused you, and we tell you whether it's worth going to the federal court to challenge the decision. So if it's worth challenging the decision, we'll tell you what we can do for you, what we're going to do for you. We're going to tell you the services we're going to render, how we're going to help you to challenge this refusal decision by the visa officer that you don't even know the visa officer's name. So you just have the visa office address. Okay? So our job is to help you to challenge the decision at the federal court level and tell them that they got it wrong. So if you feel that you've been wrongly that this decision is not justified, that is wrong, that you feel that the visa officer did not properly take a look at your application and the grounds they refused you on is wrong, contact our office. We'll be happy to help you to challenge the decision at the federal court level. Okay? So what do we do when you retain us? Number one, we first file an application for leave and judicial review. There's a number of days. This is very important. There's a time limitation to challenge the decision. So if you're refused on January 1, 2000, don't wait till April or May to contact us, because time will have passed there. So if, for example, you're in Nigeria or Ghana or Dubai, or you are in Mexico or you are in the United States and you are refused a visitor's visa, okay, or a study permit or a family sponsorship, from the date of the refusal, let's say it's January 1, 2000, you are outside of Canada when you were refused, you have 60 days to challenge the decision, either from the date of the letter or the date you received it, the date you became aware of the decision. So if you became aware of the decision on January 15, that's when you opened your email box and then you saw the refusal letter. Okay? 60 days from that date, you have to challenge the decision, or else it will be difficult to go and challenge it in the court. That will require asking for extension to file an application for leave and judicial review. You don't want to do that. So as soon as you get that decision, I pray everyone get a positive decision in any application they do for Canadian visa. But if you're refused, make sure you contact our office right away so that we can help you to challenge this decision if we think it is worth challenging, okay, at the federal court level. So if it's a decision that was made outside of Canada, okay, you have 60 days from the date of the decision, or depending on the situation, from the date you received the decision, that you became aware of the decision. So contact our office. So we file an application for leave and judicial review. That's the first thing we file. Once we file that and we serve it on the federal government, the Canadian Immigration Department, their lawyers, once we serve it on them, then what happens is they have to release all the computer notes of the visa officer. That's when you get an idea what the visa officer was thinking when they made the decision to refuse your application. What was going on in their head? What were they thinking? What was the visa officer thinking? What rationale did he use to refuse you? Is it justified? Is it right? Or is it wrong? You will see all those computer notes that they've made from the time they receive your application. It's called GCMS notes, Global Case Management System notes. The computer notes, they will release it to us. There's a timeline to release it. It contains all the things that they were thinking about when they receive your application. From the date they receive it, you will see everything in there. And all the errors that they made. Usually I like to spot the errors. I enjoy spotting the errors because it gives you, my clients, a chance to overturn this decision, to have it set aside and have a different officer redetermine the application, to take a second look at the application. I enjoy spotting the errors. It gives me joy to be able to help people, okay, to fulfill their dreams. So when I spot the error, when I release the computer notes towards the GCMS notes, I look through it, I comb through it very well. And when I spot the errors, I'll draft my legal submissions, and at the same time start drafting your affidavit. The affidavit is to set out what your perspective about the case, about your file, what went wrong, what you think the visa officer got wrong, what errors they made on the application. So when the affidavit is ready and my legal submission is ready, then I'll go and serve it on the immigration department, their lawyers. I'll go to their lawyer's office and say, these are legal submissions. And from that time, I'll go to the federal court also, and also file a copy with the federal court so that they have a copy of the legal arguments and your affidavit, your own perspective about the case too. Because you have a voice. This Canada, we have rules. A government decision can be challenged. So when they write in that refusal letter, oh, you are welcome to reapply. Yes, you are welcome to reapply. But the thing that they don't tell you in that letter is that you can also challenge the decision at the federal court if you feel that you've been wronged. So if you've been wronged, contact our office again. Our WhatsApp number is +1 613 799 7572. I will be happy to help you to put your case forward. So when we serve the Justice Department, which is always the lawyers, the department that is representing the Immigration Department, that's where their lawyers are. So we serve it on them and tell them these are arguments. This is the reason why we think your client, the Immigration Department, got it wrong. And that's why we're still fighting this case. In some cases, the Immigration Department will look at our argument and say, listen, it's not worth it to continue with this litigation, and they will make an offer to settle your case. Yes, several times we've had cases settled because they saw the merit of our arguments. That's a good thing for our client because it shortens the litigation period, and the file is then, redetermined. Say it is redetermined by a different visa officer. So another visa officer will take a second look at your application and then determine whether to issue the visa. In most cases, in my over 15 years of experience, in most cases, the visa is usually issued. Let me just recap and then continue on. You're refused. You come to our office, we look at the case, we think there's merit on it to pursue the case at the federal court. So we file an application for leave and judicial review after you retain us. We serve it on the Immigration Department, their lawyers, which is usually represented by the Justice Department. They will release the computer notes to us, that's the Global Case Management System notes. We take a look at the notes, a close look at the notes, scrutinize it. That's what the visa officer was thinking. He puts all his thoughts or her thoughts in the visa notes, and we spot the errors. We draft our legal arguments. We draft an affidavit for you to show your perspective about the case, what the visa officer got wrong. After we prepare all this, we have 30 days to make sure that we file it on the we serve it on the Justice Department, because from the day they release the computer notes to us, we have 30 days to put all our arguments together. So we put everything together, we serve it on the Justice Department, which is the lawyers, representing the Immigration Department, and then we file a copy at the federal court. At that time, the lawyers for the Immigration Department may recommend to their client, which is the Immigration Department, that they should settle the case. The Immigration Department may decide to settle the case because they don't see that it's worth pursuing this case further, that there is merit, there's too much errors on this case. So the case is set aside and a determination is made by a different visa officer. At that point, when this case is settled, we file what we call the notice of discontinuance. With your permission, we file a notice of discontinuance at the court that, listen, because we've concluded this case, we're not continuing with it. A settlement has been reached. And then the visa officer takes over the case again with a different visa officer, taking a look at it, and then hopefully the visa office issues a visa to you, and then you're able to pursue your dream of coming to Canada, whether it's for visit or study or work permit or permanent residence, bringing your loved one to Canada permanently. So that concludes the case. But in some cases, the Immigration Department may refuse to settle. At that point, if they refuse to settle, they too have 30 days to file what we call the application record, the respondent's record, to show why our arguments does not have any merits. So the Immigration Department will file their own counter arguments to show why the visa officer got it right. At that point, the court will have our own application record and the respondents, which is the Immigration Department, the respondents' memorandum of arguments. The judge will take a look at both and then determine which one has merit, which one makes sense. Did the visa officer get it right, or they got it wrong? If the court decides that we have merit, that the arguments make sense, a hearing date will be scheduled. So their lawyers will come to court. We will also come to court. I will come and make some arguments on your behalf. There are the other paperwork that we need to file before the court hearing date. But basically, a hearing date is scheduled, and we show up in court, and we make oral arguments before the judge. The judge will definitely have questions. We answer the questions as best as we can on your behalf and put your best foot forward before the court. If the court agrees with us, what happens at that point is that the court will set aside the case, the refusal, and then ask a visa officer, a different visa officer, to redetermine the case, to take a second look at your case. In some cases, the court may look at the two documents, the respondent's memorandum of arguments and our own application record, and decide in the visa officer's favor. In such a case, it concludes the case. It's not going forward anymore. That means you lost. The good thing about Olalere Law Office is that we've handled several court cases at the federal court level, and we've been successful in most of our cases. We've had some refusals, yes, but in most cases we've been successful either through settlement or at a court hearing. So don't be disillusioned. If you're refused any kind of visa, whether it's study visa, visitor's visa, permanent residence, work permits, come to our office, call us, and we'll be happy to help you. You just need to retain our services, and we'll be happy to help you. If you enjoyed today's YouTube video, please don't forget to subscribe and tell your friends about us. We also look forward to your comments. I want to see what your perspective is about this presentation. So please provide your comments below. Thank you very much, and have a good day.